of the submission that in any case, voting for a Rajya Sabha election is not entitled to this immunity because it is not a vote. It is not a legislative vote. That is the submission. And that is where the distinction which I had drawn, Millets, I will highlight that no, it doesn't have to be a legislative proceeding in the sense of voting in a house of the legislature. It is part of a legislator's function as a legislator. Article 80 of the Constitution constitutes the electoral college for the Rajya Sabha. And MLA is constitutionally made part of that electoral college. So one of the essential duties of an MLA is to vote for a Rajya Sabha election. So this voting, though not on the floor of the House, but in the lobby of the House, is nevertheless a vote in the legislature. And so, if there is a protection for a vote on a bill in the House, equally the protection should apply to a constitutionally mandated role of an MLA to vote in a Rajya Sabha election. Lordship.
Whose case is it that it doesn't extend?
The Attorney General's case, Minister. One of their reasons for saying that this reference is not necessary, they contended before the 5-judge bench also, was that in any case, Narasimha Rao will not apply. Lordship, please, Lords. Now, my Lords, can I take my Lords straight to my written submission, Volume 1. Page 12 minutes, the relevant portion starts. Under the subheading D minutes, whether the concept of parliament.
Just 1 second. How long would you take? About an hour or so today?
Well, it will go a little beyond lunch minutes. I can't say it will be over in an hour minutes. It will go, that's my estimate minutes.
A little beyond lunch, just so that we can have an assessment of everybody. We are, of course, continuing the hearing. Mr. Patwalia, the mic is, how long will it take?
Depending on how much of the judgment is read by my learned friend, about an hour, hour and a half.
Actually, what we could do is we can hear Mr. Patwalia ideally after the others have argued. Wouldn't that be better? Because, we then have a complete unfolding of the case by everyone. And then as a Amicus, you can then wrap it up for us. And
after him, Lord, just to give the counter view.
Because Mr. Ramachandran is alone against all of us.
Yes.
Right.
He is effectively going to be taking the burden of saying Narasimha Rao is right.
Right. All of you are on this side. So once, according to once Mr. Patwalia concludes, then of course we like the attorney to give us his vision, because that's it's a constitutional interpretation.
Maybe we can give Patwalia a little bit more after the attorney also. So that
If the amicus and we can complete.
I also.
I'm starting from here. Why?
Can it be like this?
Because the link will go in any case to us once I show.
That if I have the benefit of the amicus assistant,
Then
probably I can refine my thoughts further.
Exactly. All right. Then that's perfect. Then we'll hear Mr. Patwalia right after Mr. Ramachandran.
Right.
And then
We are supporting the amicus.
and then you can see what else is remaining. Of course, then the attorney can.
Remains the attorney minus the learned SU.
Of course, of course. We'll see, of course. You're here, right? No difficulty. But we like to hear an intervener only if a junior is arguing for the intervener, not if a senior is. Then we have enough seniors on the. But if you are arguing personally, then we'll give you an opportunity before the 7 judges.
Then we don't hear Mr. Gopal Shankar Narayan also.
Who are really ready for argument.
Well, the juniors who are ready, we'd certainly like to hear you because you must be given an opportunity to appear before the 7 judges.
Let's, page 12.
By all standards, is tomorrow.
Yes, we all understand that. We all understand that.
So we take the alternative list now because this matter is well and substantially now underway. So the other members of the bar who want to hear this matter, of course, you're most welcome to sit in the court, but we're not going to take the alternative list today. The alternative list will discharge the board. Yes.
Yes. Page 12 of volume 1.
Yes.
Under the heading minutes, whether the concept of parliamentary oblique legislative privilege as it stands today needs to be further refined, if not altered.
Yes.
D. Subheading D towards the bottom of page 12. My lords have got minutes? Subpara 14. The need to further refine the already refined concept of parliamentary oblique legislative privilege may be viewed from 3 standpoints. A. The law of judicial certainty and stare decisis. B. Parliament's views on this matter. C. The unintended consequences which may arise as a result of amending the law by judicial interpretative tools. Now, on this aspect of judicial certainty, I've culled out the principles and I'll cite 3 or 4 cases, just the relevant parts. It is a well-settled principle that law should not be unsettled merely on the ground that an alternative view appears to be more reasonable. A judicial precedent cannot be set aside unless A. Certain patent aspects of the question had remained unnoticed and the attention of the court on the previous occasion was not drawn to any relevant and material statutory provisions or judicial decisions. B. There was an error in the previous judgment, provided the error had a serious impact on the general administration of law. C. The previous judgment has not been consistently followed in subsequent decisions. That doesn't apply here at all because this has held the field minutes for so long. D. There has arisen a social, constitutional, or economic change since the pronouncement of the previous judgment, necessitating a change in judicial stand. There can be a sea change in thinking, as in the 377 case, or in the context in which ADM Jabalpur was overruled. It was a complete change in thinking, There is no such need in this case as what I am going to submit, since political corruption was a phenomenon very much prevalent from 1967. Ayaram and Gayaram came in 1967. It's not a recent phenomenon. Now, 3 or 4 decisions. Keshav Mills, para 23. Volume 5, 2 page 87 and para 23 at 294.
Volume 5.
Volume 5, page 287, the judgment starts. Somewhere in the middle, somewhere in the middle of para 23 at page 294. Sentence starts, but different considerations must inevitably arise because earlier was whether you can set aside the judgment of the High Court. So obviously different considerations apply, but different consideration must inevitably arise where a previous decision of this court has taken a particular view. Justice Padiwal has got it, minutes.
Which paragraph are you?
Para 23 minutes at page 294. Thanks.
It starts.
In dealing with the
dealing
question.
with
That's right.
as to whether the earlier decisions.
That's right. That's right.
Correct.
Then, minutes, I'm taking my lord straight to the middle of the paragraph.
Okay.
But different consideration must inevitably where a previous decision of this court has taken a particular view as to the construction of a statutory provision, as for instance, section 66(4) of the Act. When it is urged that the view already taken by this court should be reviewed and revised, it may not necessarily be an adequate reason for such review and revision to hold that though the earlier view is a reasonably possible view, the alternative view which is pressed on the subsequent occasion is more reasonable. In reviewing and revising its earlier decision, this court should ask itself whether, in the interest of the public good or any other valid and compulsive reasons, it is necessary that the earlier decision should be revised. When this court decides questions of law, its decisions are, under Article 141, binding on all courts within the territory of India, and so it must be the constant endeavor and concern of this court to introduce and maintain an element of certainty and continuity in the interpretation of law in the country. Frequent exercise by this court of its power to review its earlier decisions on the ground that the view pressed before it later appears to the court to be more reasonable may incidentally tend to make law uncertain and introduce confusion which must be consistently avoided. That is not to say that if on a subsequent occasion this court is satisfied that its earlier decision was clearly erroneous, it should hesitate to correct the error. But before a previous decision is pronounced to be plainly erroneous, this court must be satisfied with a fair amount of unanimity among its members that a revision of the said view is fully justified. It is not possible or desirable, and in any case, it would be inexpedient to lay down any principles which should govern the approach of the court in dealing with the question of reviewing and revising its earlier decisions. It would always depend upon several relevant considerations. What is the nature of the infirmity or error on which a plea for a review and revision of the earlier view is based? On the earlier occasion, did some patent aspects of the question remain unnoticed? Or was the attention of the court not drawn to any relevant and material statutory provision? Or was any previous decision of this court bearing on the point not noticed? Is the court hearing such plea fairly unanimous that there is such an error in the earlier view? What would be the impact of the error on the general administration of law or on public good? Has the earlier decision been followed on subsequent occasions, either by this court or by the high courts? And would the reversal of the earlier decision lead to public inconvenience, hardship, or mischief? These and other considerations must be carefully borne in mind whenever this court is called upon to exercise its jurisdiction to review and revise its earlier decisions. These considerations become still more significant when the earlier decisions happen to be a unanimous decision of a bench of 5 learned judges of this court. Of course, this particular decision is not a unanimous decision. Then, minutes.
But Mr. Ramchandran, in your formulation in paragraph 15 of your written submission,
Lordship, please, minutes.
you say a judicial precedent cannot be set aside unless, and
Yes.
then you sort of break up all the questions which are raised by Chief Justice Garnagadkar into A, B, C, and D.
Lordship, please.
Now, what the judgment in Keshavamil lays down are illustrative
Lordship.
of when a review can take place or revision can take place, as they call it. They're not exhaustive.
No, they say so much. That line, I read out that line which says it's not possible to give a complete. Yes, minutes.
And above all, they emphasize the aspect of public good.
Lordship,
What
please,
is
minutes.
it for the polity?
I bow to that, minutes. And I am going to submit, when I come to Narasimha Rao's judgment, that this court was the majority itself was very conscious of this concept, minutes, of public good. And that's why, in spite of our sense of indignation, as the expression used, it is not that the court was oblivious of that. Rule of law was, after all, minutes, and is always an overarching consideration when this court decides any constitutional issue, minutes. There's nothing which the court lost sight of, but the court weighed and then preferred the view which the court felt the plain language of the constitution warrants.
Right. Apart from Keshav Mills, do you want to cite anything?
Yes, but I would cite one more, minutes. The other I've given minutes, Krishan Kumar and Shankar Raju, but I'll just cite Shah Faisal minutes because it's more recent. That was minutes when the earlier 5-judge bench in the Article 370 case minutes, a request was made to refer to 7 judges questioning Sampath Prakashan. Lordship, please. So minutes, that I'll take my lord straight to 2485 at volume 5 is where the judgment starts, and the relevant part is at 2494. Para 17. Para 17 minutes, can I read minutes? If all my lords have got minutes.
Yes.
This court's jurisprudence has shown that usually the courts do not overrule the established precedents unless there is a social, constitutional, or economic change mandating such a development. The numbers themselves speak of restraint and the value this court attaches to the doctrine of precedent. This court regards the use of precedent as an indispensable bedrock upon which this court renders justice. The use of such precedents, to some extent, creates certainty upon which individuals can rely and conduct their affairs. It creates a basis for the development of the rule of law. As the Chief Justice of the Supreme Court of the United States, John Roberts, observed during his Senate confirmation hearing, it is a jolt to the legal system when you overrule a precedent. Precedent plays an important role in promoting stability and even-handedness. 18 and 19, I'll make a brief reference minutes. 18 particularly, doctrines of precedents and stare decisis are the core values of our legal system. They form the tools which further the goal of certainty, stability, and continuity in our legal system. Arguably, judges owe a duty to the concept of certainty in law. Therefore, they often justify their holdings by relying upon established tenets of law. When a decision is rendered by this court, it acquires a reliance interest and the society organizes itself based on the present legal order. When substantial judicial time and resources are spent on references, the same should not be made in a casual or cavalier manner. We have crossed that stage because the reference has been made. We are now minutes on whether it should be reconsidered minutes, this particular judgment. I won't read further from here. Minutes. Now minutes, I've dealt with one from my bullet point note minutes. Now, 2, 3, 4, and 5, I'll be dealing with together when I place minutes the majority and minority views in the Narasimha Rao case. All these 4 will get covered minutes when I place that. And minutes, before I come back to my written submission minutes, I wish to draw attention to a passage from Blackstone minutes with regard to the origin of this concept of privilege and how that very thought finds reflection in Justice Bharucha's judgment. Let me take my lord straight minutes to volume 4. 1481, just take it out from my submission here. You take it. Yeah, here it is.
Um,
Yes, Lords.
Volume 4.
Volume 4 minutes at 1487. If all my lords have got minutes, I can place the passage straight away. The privileges of Parliament, the lower part minutes, the lower paragraph. The privileges of Parliament are likewise very large and indefinite, which has occasioned an observation that the principal privilege of Parliament consisted in this, that its privileges were not certainly known to anyone but Parliament itself. And therefore, when in 31, Henry VI, the House of Lords propounded a question to the judges touching the privileges of Parliament, the Chief Justice, in the name of his brethren, declared that they ought not to make an answer to that question, for it has not been used aforetime that the judges should in any wise determine the privileges of the High Court of Parliament, for it is so high and mighty in its nature, that it may make law, and that which is law, it may make no law, and the determination and knowledge of that privilege belongs to the Lords of Parliament and not to the justices. Privilege of Parliament was principally established in order to protect its members not only from being molested by their fellow subjects, but also more especially from being oppressed by the power of the crown. It therefore, all the privileges of Parliament were once to be set down and ascertained, and no privilege to be allowed. But what was so defined and determined, it were easy for the executive power to devise some new case, not within the line of privilege, and under pretense thereof to harass any refractory member and violate the freedom of Parliament. Therefore, the central thought which I wish to emphasize, based on the historical origin of privilege, is criminal law is one aspect of the public good, of public policy, but the independence of members of the Parliament from the crown, and in a democracy substitute it with a democratic executive. It is equally an important factor. And that is where I'll place that relevant passage from Justice Bharucha's judgment. This one? Yeah. Now, this one?
Yes, Mr. Ram.
Yes, sir. No. Can you give me a minute, sir?
Yes.
No, I'm on this. Take from the executive. It is not our end. Your Lordship will just give me half a minute more, that particular line which I wanted to read at this particular point, But I may start by reading the judgment in the meantime, Para 133, volume 5, page 808. No, I will come back to that passage, but it's part of the same judgment, so I'll emphasize it. 133 onwards,
Volume 5.
Of Narasimha Rao, volume 5 minutes. No? 136.
Exactly. Broadly.
Para 133 onwards, I'm reading. Page number 808. Can I read,
Yes.
Broadly interpreted, as we think it should be, Article 1052 protects a member of Parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or a vote given by him in Parliament. The charges against the alleged bribe takers is that they were party to a criminal conspiracy and agreed to or entered into an agreement with the alleged bribe givers to defeat the no confidence motion by illegal means, namely to obtain or agree to obtain gratification other than legal remuneration from the alleged bribe givers as a motive or reward for defeating the no confidence motion, and in pursuance thereof, the alleged bribe givers passed on several lakhs of rupees to the alleged bribe takers, which amounts were accepted by them. The stated object of the alleged conspiracy and agreement is to defeat the no confidence motion, and the alleged bribe takers are said to have received monies as a motive or reward for defeating it. The nexus between the alleged conspiracy and bribe and the no confidence motion is explicit. The charge is that the alleged bribe takers received the bribes to secure the defeat of the no confidence motion. While it is true that the charge against them does not refer to the votes that the alleged bribe takers, Ajit Singh excluded, actually cast against the no confidence motion, and that it may be established he hoarded those votes, as the Attorney General argued, we do not think we can ignore the fact that the votes were cast, and if the facts alleged against the bribe takers are true, then they were cast pursuant to the alleged conspiracy and agreement. It must then follow, given the expression in respect of must receive a broad meaning, that the alleged conspiracy and agreement had a nexus and were in respect of those votes, and that the proposed inquiry in the criminal proceedings is in regard to the motivation thereof. It is difficult, this paragraph is important, minutes, in the context of Blackstone as well. It is difficult to agree with the learned Attorney General that though the words in respect of must receive a broad meaning, the protection under Article 1052 is limited to court proceedings that impugn the speech that is given or the vote that is cast or arises thereout, or that the object of the protection would be fully satisfied thereby. The object of the protection is to enable members to speak their mind in Parliament and vote in the same way, freed of the fear of being made answerable on that account in a court of law. It is not enough that members should be protected against civil action and criminal proceedings, the cause of action of which is their speech or their vote. To enable members to participate fearlessly in parliamentary debates, members need the wider protection of immunity against all civil and criminal proceedings that bear a nexus to their speech or vote. It is for this reason that a member is not liable to any proceedings in any court in respect of anything said or any vote given by him. Article 105 does not say what it would have if the learned Attorney General were right, that a member is not liable for what he has said or how he has voted. It would have then been worded differently. While imputing, this is important, minutes. I'm linking this to what Blackstone said then, minutes. While imputing no such motive to the present prosecution, it is not difficult to envisage a member who has made a speech or cast a vote that is not to the liking of the powers that be, being troubled by a prosecution alleging that he has been party to an agreement and conspiracy to achieve a certain result in Parliament, has been paid, achieve a result in Parliament and had been paid a bribe. Therefore, minutes, a powerful executive, whatever be the ruling party, minutes, it's a fact of political life in India today, minutes, that the law is misused. So this is an equally important consideration. If a member is to vote fearlessly, he should be free from the fear of prosecution. And therefore, it is not just, millards, an immunity from criminal law. Right. Yeah, after I finish this, I'll come there. Para 137.
137.
Yes, sir. We are acutely conscious of the seriousness of the offense that the alleged bribe takers are said to have committed. If true, they bartered a most solemn trust committed to them by those they represented. By reason of the lucre that they received, they enabled the government to survive. But so, they are entitled to the protection that the Constitution plainly affords them. Our sense of indignation should not lead us to construe the Constitution narrowly, impairing the guarantee to effective parliamentary participation and debate. So the majority was equally anguished, my lords. This is not an amoral judgment. The majority would have been as shocked as any court would have been, as any conscientious citizen would have been. But the majority said we must read the Constitution as it is written. And there is reason for it. Members need protection. And then, my lords, as far as criminal prosecution is concerned, you can't differentiate between corruption and defamation. If there is protection from criminal prosecution, it has to be in all respects, my lords. As long as it bears a nexus. In Ajit's case, my lords, this honorable court sufficiently refined it, my lords, in the recent Kerala Assembly case. If a member commits an act of vandalism, or let's take an extreme case of a physical assault, then it is obviously not protected, because by no standard can it be said to have a nexus, minutes. Similarly, that test may perhaps conceivably be applied to a hate speech situation on the floor of the House also, minutes, as to whether it had any nexus at all with the role of the member in the performance of his duties. But, minutes, once that immunity is there, then we can't, minutes, dissect it and say corruption shocks us, defamation is of a different character, defamation is more political in character. It has to be absolute protection, minutes. And therefore, minutes, this anguished conclusion of the majority, bearing in mind what weighed with the Constitution makers, bearing in mind the historical background of privilege, is not even 25 years later something which would shock the conscience of this court, minutes. To repeat, minutes, political corruption is a fact of modern political life, and, minutes, perhaps historical and ancient political life also, minutes.
Yes.
And this, and I'm going to emphasize when I come back to my written submission, minutes, it is not that the Constitution gives a complete carte blanche. After all, the privileges of Parliament are to be exercised by Parliament itself against its members. And we may trust Parliament to do so, on given occasions. In the early years, my lords, in the provisional parliament, and I've given that instance in my written submission, I'll take my lord to that straight away, my lords. A member, one Mr. H.G. Mudgal, was expelled by the House for, my lords, accepting a bribe to ask a question in the House. From 1952 to Rajaram Pal in 2006, it is not that Parliament has not exercised its power. And so the Constitution leaves it to Parliament to take care of aspects of political morality, then I would respectfully submit that the court, out of a sense of moral outrage, ought not to proceed further. And that is the error in Justice Agarwal's judgment, my lords, and I'm going to place that passage straight away. Justice Agarwal is conscious of the fact that the power to expel is there. But the judgment says that is not a satisfactory solution. That's the fundamental error, my lords. And I say this with great respect, that it is not for the court to find perfect solutions to all moral dilemmas, political problems, political conundrums, my lords.
But
The
Mr.
Constitution makes us-
Mr. Ramchandran, if you really interpret 105(2), the Justice Bharucha rejected the submission of the Attorney General based on the words "in respect of." Let's look at 1052. What does it say?
Yes, please. Let's go.
No member of Parliament shall be liable
To any proceedings
to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. So what this really means is that a member of Parliament, it says, shall be liable to any proceedings. Shall be liable to means shall be answerable to or shall be held to account in any court. So once a member of Parliament has either cast a vote or has spoken, they will not be answerable in any court of law in any proceeding for the vote which they have cast or the speech which they have made. That's all. And that dovetails with clause 1. Clause 1 begins by saying there shall be freedom of speech in Parliament. And then 2 says that freedom of speech in Parliament is protected by saying you will not be held to account in a court for a speech which you made. No court can say that, well, why did you make this speech? Or you're answerable to us as a judicial institution in respect of a speech which you made or a vote which you cast. That's the purpose. This does not really seek to implicate other aspects, such as an aspect of criminality. Now, some aspects of political morality are dealt with by the Constitution itself, in the 10th schedule, for instance.
Lordship, please, lords.
Okay,
Which
so
came
if
later?
I-
Which came later?
Which came much later. But for instance, the 10th schedule will deal with certain aspects of political morality, namely crossing of floors, casting, acting against the whip, or a defection from the political party. But to read the words "in respect of" have to be construed appropriately. You're right. Normally, "in respect of" is not treated as a word of limitation. "In respect of" is always interpreted in a very broad perspective. In relation to, in respect of. But what is in respect of what? In respect of anything said or any vote given. Will this go beyond a criminal consideration underlying the speech or the vote? Of course, there is a possible view. I mean, you can't, that's why, that's why that judgment is there, obviously, too. The majority has taken that view and we respect that view. What seems to have weighed with the majority is that if you cannot be responsible in respect of a vote given or a speech made to any court in a proceeding, then the underlying motive for the casting of the vote or the speech, whether it is criminal or otherwise, equally immune
Lordship, please.
from court proceedings.
Lordship, please, my lords, and
The question is whether you therefore stretch that in respect of to cover an underlying motive or an underlying consideration being criminal as also being immune, or whether does it stop with the vote cast or the speech which is given, and does it really also extend to a possible criminal misdemeanor in the casting of the vote or the making of the speech?
just a respectful refinement of what my lord the Chief Justice has put to me.
Just
My-
Straight away here. Show it here. Okay, you should.
My lord was
Is, I mean, this is the things. When one question is, the way you read sub-article 2 is perhaps is in two parts. The first part relates to the vote given by him in the parliament. Anything said or vote given. The later portion which comes after end, after the comma, talks about liability with respect to publication by or under the authority of either house of the parliament of any report, paper, vote or proceedings. This later portion talks about the liability with respect to publication, etc. The first part talks about the vote as well as what is said. There is a distinction there.
Sorry to interrupt, also member of parliament versus person. First part is member of parliament, second part is person.
no person shall be.
Person.
liable.
So
My friend
therefore,
is
there
right.
is a clear distinction there. So whether with the expression in respect of attached to the first part is a question perhaps that just came to my mind.
Lordship, please, my lords.
That is one thing.
Lordship, please.
Does it attach to a pristine situation where a member of a parliament says or votes in a parliament? This has to be read in consonance with the first sub-article 1. Maybe there is perhaps a distinction there because, as they say, publication also,
Yes, ma'am.
and what is published with respect to the proceedings of the house also attaches some amount of immunity. That is what is said.
So the Lok Sabha debates, the Rajya Sabha debates.
There could be something, yes, my lords.
And that will also attach to a staff of the legislature. The Secretary General of the Lok Sabha,
Yes, my lords, the printer and publisher also.
who will publish a report of the text of the proceedings in the parliament, would be equally immune because no person shall be liable in respect of the publication.
Therefore, the use of the word person,
Person.
because they are
Much broader.
expanded beyond the member concerned.
That's right.
There's a long English parliament.
Private public.
Right. That's by or under the authority. Something which is an authorized publication of parliament.
So which is that expression which connects, so to say, as the later part uses the expression in respect of, so far as the first part is concerned?
Yes, my lords.
That's the question. That's a question.
Lordship, please.
But otherwise, the other principle that the concept, the activity of corruption, which occurs outside the house, has got nothing to do with what is said and the vote which is being made in the parliament. That's the first part of it. But what, according to you, controls that?
Yes, Lordship.
The first part.
I'll read the sentence again. I'll read the clause again. No member of parliament
My question was slightly different.
Lordship, please. No?
So that consequence of the speech made, consequence on the publication made. These are the only two conditions.
Lordship, please.
Anything happened prior.
That is where in respect of comes for the.
I'll give you one more. Suppose a bribe has been taken by a member of the legislature for casting a vote in a particular manner, for making a speech. A court cannot therefore say that please invalidate this vote because it was motivated by a bribe. Suppose a person is convicted for the offense of bribery. Can a court say that therefore that vote should be excluded in computing the parliamentary majority? Suppose 20 members of the legislature are proved to have accepted a bribe. That vote is still a valid vote,
Lordship,
cast in favor of or against the motion.
Contextualized. Clearly, it is contextualized in the first part as well as second part when they use that in respect of a vote and what is said and in respect of what is published.
Lordship, please.
Both are very clearly contextualized.
Lordship, please. And Millets, in my respectful submission.
You can't say impugn a resolution passing a legislation or passing the budget on the ground that any of the votes which were cast
To pass the
were
finance.
vitiated by a criminal wrongdoing.
If that be so, if I may.
But that immunity which attaches to the vote which is cast does not attach to the crime which takes place independent of the casting of the vote or the rendering of the speech.
My respectful submission is, if the crime, the anterior crime, so let us assume Millets, and that is a matter of law, Millets, there can be no two views about it. That the offense.
Let me put your argument at its best, at the highest.
Lordship, please.
That the anterior crime of accepting a bribe for casting a vote or making a speech is integrally related
Lordship,
to
please.
the casting of the vote or the making of the speech.
That is my argument, Millets, and that's
And
my.
once both are integrally related, according to you, the immunity must attach to both.
In respect of,
Submission
from
rate.
Justice Narasimha's
That's
question
part of
also,
it.
is
The reason of highlighting what you have said of in the previous quotation of Blackstone is as it becomes necessary because of the reason that the executive
Lordship, please.
has a control over the members through some manner or the other. So therefore, the need for an immunity to
Grateful.
extend even to that.
Grateful.
That's your argument.
I'm grateful. And apropos,
Yeah,
the observation.
Please just elaborate what Chief is saying is this. In a case where, let us assume there's a bribery, voting take place. Then on the question of validity of the vote, a decision is made within the parliament, that cannot be questioned.
No, it cannot. That
To that
undoubtedly
extent-
can be.
To that extent, there is a casual connection,
Lordship, please.
notwithstanding that. But other things, they stand apart. Then criminality stands apart. That has got nothing to do with the parliament.
But that is where my argument that in respect of,
To that extent, the parliament can, the house can go into whether bribe is there or not, whether vote is there or not. To that extent, it can go into. To either validate or invalidate the vote, it can go into.
Lordship, please, Millets, but.
Now in PV Narasimha Rao itself, the no confidence motion was defeated, right?
Yes, ma'am.
The court couldn't have said that the no confidence motion has to be now, you have to be now reviewed. And we will therefore now see whether the new no confidence vote was passed or otherwise. by excluding the votes of persons who had improperly voted in favor
No, it's,
or against the motion.
There are two things, Mr. Ramchandran, that not voting is different and voting consequences are different is one aspect of the matter. Another aspect of the matter is the scope and extent of the immunity.
Correct.
That we need to balance the constitutional intendment of to what extent the constitution intended that the immunity must be extended
Purpose for it.
in the context of speech as well as the vote.
Lordship, please.
How
Lords.
deeper it is depending on what kind of a mischief could happen with the executive intervention. So that's a matter of interest.
Lordship, please.
Yes,
And-
just to expand this, what we are saying, it can at best be restricted to the business which the parliament expected to transact. Nothing more, as Manala said, let us take some murder takes place. Now, can we say that parliamentary privilege?
No.
We are trying to take
Yes.
a very larger proportion. Then nothing can be done. Supposing some decision is taken, it can be questioned.
It can be, Lords.
So it can be only restricted to this freedom of speech and expression.
No, there always has to be a nexus with an MP or MLA's work or duty as an MP or MLA, Millets. And this is without, Millets, I'm not going to my later submission that voting for Rajya Sabha also, not just legislative voting, is also part of the work of an MLA, but it has to be connected with that. And therefore, apropos the observation of the learned Chief Justice as to whether in respect of can be stretched, that was my Lord the Chief Justice's observation. There, my respectful submission is, it is not a question of stretching. The question is, can in respect of be restricted? Can in respect of be restricted? We are not stretching. The language is plain and unambiguous because there is a nexus, there is a causal connection. Then can it be restricted or whittled down? Because it is a crime of a particular nature, which is morally abhorrent. My respectful answer on the plain language of the Constitution is no, it can't be whittled down. We are not expanding in respect of, we are unjustifiably restricting in respect of, which ought not, Millets, to be done. Can I, Millets, take my lords to Justice Agarwal's judgment, just a couple of paragraphs, Millets. Paras 45 and 47, volume 5, page 751.
Para 47.
Para 45 first, Millets.
Yes.
Page 751, volume 5, if all my lords have got bills. It is no doubt true that a member who is found to have accepted bribe in connection with the business of Parliament can be punished by House for contempt. But that is not a satisfactory solution. This is where, Millets, value judgment, moral judgment, etc. come in, Millets. And this is where the court has fallen into error. The minority has fallen into error. It is with respect not for the court to find a solution to what seems to be illogical, let's put it even more strongly, unfair in the Constitution. No, it is there in the constitution. It is part of the original constitution. And therefore, that exemption, that exception, that immunity is as much a part of the pillar of the constitution, and therefore not in the basic structure kind of test words, but that is also part of the constitution. That's part of the constitutional architecture. Then minutes. Paras 46 and 47. The expression in respect of has to be construed in this perspective. The cases cited by Sri Rao do show that this expression has been construed as having a wider meaning to convey some connection or relation in between the two subject matters to which the word refers. Words refer. But as laid down by this court in State of Madras versus Swastik Tobacco Factory, the expression has received a wide interpretation having regard to the object of the provisions and the setting in which the said words appeared. The expression in respect of in Article 1052 has therefore to be construed keeping in view the object of 1052 and the setting in which the expression appears in that provision. As mentioned earlier, the object of the immunity conferred under Article 1052 is to ensure the independence of the individual legislators. Such independence is necessary for healthy functioning of the system of parliamentary democracy adopted in the Constitution. Parliamentary democracy is a part of the basic structure of the Constitution. An interpretation of the provisions of Article 1052, which would enable a member of parliament to claim immunity from prosecution in a criminal court for an offence of bribery in connection with anything said by him or a vote given by him in parliament or any committee thereof, and thereby place such members above the law, would not only be repugnant to a healthy functioning of parliamentary democracy, but would also be subversive of the rule of law, which is an essential part of the basic structure of the Constitution. It is settled law that in interpreting the constitutional provisions, the court should adopt a construction which strengthens the foundational features of the basic structure of the Constitution. No doubt about that, Mills. There is no quarrel with that proposition. The expression in respect of precedes the words anything said or any vote given in Article 1052. Apropos Justice Narasimha's question, Mills. The words anything said or any vote given can only mean speech that has already been made or a vote that has already been given. The immunity from liability, therefore, comes into play only if a speech has been made or a vote has been given. The immunity would not be available in a case where a speech has not been made or a vote has not been given. When there is a prior agreement wherein a member of parliament has received an illegal consideration in order to exercise his right to speak or to give his vote in a particular manner on a matter coming up for consideration before the House, there can be two possible situations. There may be an agreement wherein a member accepts illegal gratification and agrees not to speak in parliament or not to give his vote in parliament. The immunity granted under Article 1052 would not be available to such a member, and he would be liable to be prosecuted on the charge of bribery in a criminal court. What would be the position if the agreement is that in lieu of the illegal gratification paid or promised, the member would speak or give his vote in parliament in a particular manner, and he speaks and gives his vote in that manner? As per the wide meaning suggested by Sri Rao for the expression in respect of, the immunity for prosecution would be available to the member who has received illegal gratification under such agreement for speaking or giving his vote, and who has spoken or given his vote in parliament as per the said agreement, because such acceptance of illegal gratification has a nexus or connection with such speaking or giving of vote by that member. If the construction placed by Sri Rao on the expression in respect of is adopted, a member would be liable to be prosecuted on a charge of bribery. If he accepts the bribe for not speaking or for not giving his vote on a matter under consideration before the House, but he would enjoy immunity from prosecution for such a charge if he accepts bribe for speaking or giving his vote in parliament in a particular manner, and he speaks or gives his vote in parliament in that manner. It is difficult to conceive that the framers of the Constitution intended to make such a distinction in the matter of grant of immunity between a member of parliament who receives bribe for speaking or giving his vote in parliament in a particular manner and speaks or gives his vote in that manner, and a member of parliament who receives bribe for not speaking or not giving his vote on a particular matter coming up before the House and does not speak or give his vote as per the agreement as to confer an immunity from prosecution on charge of bribery or on the charge of bribery on the former, but denying such immunity to the latter. Such an anomalous situation would be avoided if the words in respect of in Article 1052 are construed to mean arising out of. In the expression, if the expression in respect of is thus construed, the immunity conferred under Article 105(2) would be confined to liability that arises out of or is attributable to something that has been said or a vote that has been given by a member in Parliament or a committee thereof. The immunity would be available only if the speech has been made or the vote that has been given is an essential and integral part of the cause of action for the proceedings giving rise to the liability. The immunity would not be available to give protection against liability for an act that precedes the making of the speech or giving the vote by a member in Parliament, even though it may have a connection with the speech. So, in respect of is here, but that is sought to be whittled down by saying, no, it must be in respect of.
Of course, this distinction which Justice Agarwal makes,
Yes, Williams.
there is in that sense an agreement with the majority also, because that is how how Ajit Singh was held not to be immune by the majority as well. So this anomaly, so-called, I mean, the anomaly is what we have used in that the third formulation which we made in the referral order. There seems to be an agreement even with the majority.
Lordship, please.
Because
Both can be prosecuted.
I think he's citing it, he's citing it as an extreme example to show the anomaly which would arise if the other construction is adopted. Actually.
That's right.
He's citing it as an.
And it was actually borne out by what the majority did ultimately, by holding that Mr. Ajit Singh is not immune.
This is actually proved by the result which flows from the majority.
The mistake, the error with respect here is this, that the compendious expression in respect of is sought by this interpretation to say arising from or arising out of to something posterior and eliminate anything happening anterior. But in respect of is a wide expression which comprehends anything anterior, anything contemporaneous, and anything posterior. There is no justification whatsoever to whittle down I would go so far as to say, be doing violence to language if we were to read in respect of in this manner. And this reading flows only from a sense of moral outrage and with a view to devising what the court feels is a satisfactory solution, because what obtains today under the constitutional scheme, according to the minority, is not a good enough solution. That's good enough. Come back to one more. Come back to.
Yeah.
Yes, please. Can I now take my lords further to my note, volume 1, page 14. After this, no, after the concept needs to be further discussed. Parliament's view on the matter.
3 years back,
Look at page 14 of my written submission, volume 1. There was a recent case, Millards, concerning the Delhi Assembly and some social media minutes. Para 18, page 14, volume 1.
Yes.
Interestingly, this honorable court, the recent case of Ajit Mohan versus Legislative Assembly, National Capital Territory of Delhi, did observe that there were divergent views among constitutional experts on whether full play must be given to the powers, privileges, and immunities of legislative bodies as originally defined in the Constitution, or is to be restricted. However, despite the divergence of views, this honorable court declined to express or impose its views on the matter, and justifiably so, as held by this honorable court. Such opinion would have to be debated before Parliament or legislature of the state to come to a conclusion one way or the other. It is not even a subject matter where it could be said that any one opinion must prevail, or a nudge must be given by this court, or a recommendation must be made for consideration by the legislative body. The court has left it, minutes, to the legislature. Considering, minutes, we assume the historical background, the high constitutional status which privileges themselves have occupied in constitutions all over the world. Then, minutes, page 15. What has Parliament felt, minutes? Because after all, the criticism has been voiced over the years, minutes. And this is always a vexed issue. Parliamentary Standing Committee reports, the relevance of which was recognized by this honorable court in Kalpana Mehta, are documents that reflect parliamentary oversight